Okay, we've seated the jury. I'm going to go ahead and give them their instructions. The instructions we're using are from the standard instructions with advice from the Office of Court Administration. Members of the jury, you have been chosen to serve on this jury. Because of the oath you have taken in your selection of the jury, you become officials of this court and active participants in the administration of justice. You have each received a set of written instructions. I'm going to read them to you now. Some of you have heard them before and some are new. 1, turn off your electronic devices that you are not using for Zoom, for the Zoom app during the trial. That means no taking phone calls, looking at text messages during this trial, or using social media like Facebook, Instagram, or Snapchat. Do not look at websites, emails, or any other materials other than the Zoom app during the trial. Do not be distracted during this trial. It is the expectation of the court and the litigants that you give your full attention to this trial. Do not close the video or audio of the Zoom app unless instructed by the court. Do not move away your camera. Jurors must take breaks at the same time, and it is not permitted for a juror to leave the view of the camera even for a quick second unless the court gives you permission. You are to view this trial alone on your electronic device. No other individuals are allowed to sit next to or be in the same room with you during any time the court is in session. You are to remain secluded while the court is in session, as you are an active participant and observer during this trial. And as such, you should protect yourself from any distractions. Do not post information about the case on the internet before these court proceedings end and you are released from jury duty. Do not record or photograph any part of these court proceedings because it is prohibited by law. 2, to avoid looking like you're friendly with one side of the case or the other, not mingle or talk with the lawyers, witnesses, parties, or anyone else involved in this case. You may exchange casual greetings like hello and good morning. Other than that, do not talk with them at all. They have to follow these same instructions, so please don't be offended when they follow the instructions. 3, do not accept any favors from the lawyers, witnesses, parties, or anyone else involved in the case. Do not do any favors for them. This includes favors such as giving rides and food. 4, do not discuss this case with anyone, even your spouse or a friend, either in person or by any other means, including by phone, text message, email message, chat room, blog, or social networking websites such as Facebook, Twitter, or MySpace. Do not allow anyone to discuss this case with you or in your hearing. If anyone tries to discuss this case with you or in your hearing, tell me about it immediately. We do not want you to be influenced by something other than the evidence admitted in court. 5, do not talk about the case with anyone during the trial, not even with your fellow jurors, until the end of the trial. You should not discuss this case with your fellow jurors until the end of the trial, so you do not form opinions about the case before you have heard everything. After you have heard all the evidence, received all my instructions, and heard all the lawyers' arguments, you'll then go to the jury room, discuss this case with the other jurors, and reach a verdict. 6, do not investigate this case on your own. For example, do not try to get information about the case, lawyers, witnesses, or issues from outside this courtroom. B, do not go to places mentioned in the case to inspect the places. C, do not inspect items mentioned in this case unless they are presented as evidence in court. D, do not look up anything in the law book, dictionary, or public record to try to learn more about this case. And E, do not look up anything about the internet, up on the internet to try to learn more about this case. And F, do not let anyone do any of these things for you. Let me just say one thing I want to focus on, and that is the use of the internet. Although we're currently on the internet and we all use the internet, obviously every day, I know I do, you're not allowed to look up anything on the case. I'll give you a quick story about something that happened at this courthouse. There was a jury trial here once where a juror looked something up and then admitted it in trial. After that case, it ended up calling that case was a multi-week case in the question. And that juror and many other jurors had to come back to the courtroom after they would have been released to provide additional testimony to see if they'd been influenced by that one juror's research of the internet. Can you guys all promise me you won't do any type of research on the internet about this case until you're released as a juror? Can everyone make that promise to me?
Promise.
Yes.
Perfect. Mr. Longoria, can you make that promise?
Yeah, I can make that promise. I just had you on mute.
Okay, that's okay. This rule is very important because we want a trial based only on the evidence presented in open court. Your conclusion about this case must be based only on what you see and hear in this courtroom, because the law does not permit you to base your conclusion on information that is not presented to you in open court. All the information must be presented in open court so the parties and the lawyers can test it and object to it. Information from other sources like the internet will not go through this important process in the courtroom. In addition, information from other sources could be completely unreliable. As a result, if you investigate this case on your own, you could compromise the fairness to all parties in this case and jeopardize the results of this trial. 7, do not tell other jurors your own experiences or other people's experiences. For example, you may have special knowledge of something in this case, such as business, technical, or professional information. You may even have expert knowledge or opinions, or you may know what happened in this case or another similar case. Do not tell other jurors about it. Telling other jurors about it is wrong because it means the jury will be considering things that were not presented in court. 8, do not consider attorney fees unless I tell you to. Do not guess about attorney fees. 9, do not consider or guess whether a party is covered by insurance unless I tell you to. 10, during the trial, if taking notes will help focus your attention on the evidence, you may take notes on paper. Do not use any personal electronic devices to take notes. If taking notes will distract your attention from the evidence, you should not take notes. Your notes are for your own personal use. They are not evidence. Do not show or read your notes to anyone, including other jurors. You may take your notes and consult them during your deliberations, but keep in mind that your notes are not evidence. When you deliberate, each of you should rely on your independent recollection of the evidence, not be influenced by the fact that another juror has or has not taken notes. After you complete your deliberation, like in a jury trial that is conducted in person, your notes should be destroyed after you've completed your jury service. 11, this is extremely important. It is your duty to listen to and consider the evidence and determine the fact issues that I may submit to you at the end of the trial. After you've heard all the evidence, I'll give you instructions to follow as you make your decision. The instructions also will have questions for you to answer. You'll not be asked, and you should not consider which side will win. Instead, you'll need to answer specific questions I give you. Every juror must obey my instructions. If you don't follow these instructions, you'll be guilty of juror misconduct. I may have to order a new trial and start this process over again. This would waste your time and the party's money and require the taxpayers of this county to pay for another trial. 12, jurors are not permitted to ask questions to a witness or an attorney during the trial. You guys understand these instructions? Everyone understand them?
Yes.
Yes.
Okay, fantastic. So what we're going to do now, let me kind of give you an overview of what's going to happen in this case. We're going to first do opening statements right now. After we do the opening statements, each side is going to have up to 10 minutes. We're going to take a break. When you take the break, would you guys prefer to leave Zoom and then rejoin, or do you want to stay in the breakout room?
Stay in the breakout room and
Yeah, breakout room is fine.
Breakout.
Yeah, why don't you stay in the breakout room?
Breakout.
We're going to take a break after we finish opening statements until 1 o'clock. Does that give you guys enough time to have lunch?
Yes.
About 50 minutes?
Yes.
And then when we come back, we're going to start with the presentation of the plaintiff's case and then the presentation of the defendant's case. At that point, we're going to break for the day. And the reason we're breaking for the day, and this is very important, there's 2 reasons. One, we have to deliver iPads to you. You might ask you, why do I need to get iPads? Because I already have a device. The reason for that is twofold. One is we need to make sure that we're going to have downloaded on each of the iPad confidential medical records and other exhibits in this case that we don't want to be sharing to everyone. So we ask you, when you get the iPad, if any of you are tech geniuses and want to, please leave the medical records in the device. Don't try to share it with other people. And then the second thing is we're going to be providing you a program on the device called Adobe Sign that will allow you to sign your verdict at the end of the trial. So does that make sense? Does anyone have any questions about what's going on?
No, Your Honor.
Okay. And it's extremely important you actually get these devices. So you have Rhonda's phone number. If for some reason there's some issue that comes up, Rhonda's my court coordinator. Do you guys all have her phone number? I think you should. We've emailed everyone. Does anyone need her phone number again? Does anyone need to take a 30-second break to get a notepad to take notes on? Does anyone need to take a break? Okay. Everyone okay? Give me a thumbs up if you're ready to start with openings.
Your Honor, I got a question.
Sure.
Your previous instructions, we can still get on the internet to do other work, right? I mean, it's not like we have to stay
That's
off.
a great question. That is a great question. You are allowed to get on the internet to do any other type of work, not during the trial, but during the break.
Right.
But just don't do any research about this case. Any other questions before we get started? All right, each side has 10 minutes for opening statements. Mr. Maldonado, you may proceed.
Thank you, Your Honor. Please support counsel. Good morning, ladies and gentlemen. So as I'm sure you've gathered, we're here about a motor vehicle collision. This incident took place on June 3rd of 2017. You'll hear my client, Mr. Escobar, testify that it was around 10 o'clock at night and he was on his way home from working at CVS. And on his way home, he was going to stop and get something to eat at Burger King. You hear Mr. Escobar testify that he was traveling on Peterson Road in between Noel and Montfort streets. As he was traveling on Peterson Road, which is a 2-lane street, 1 lane going in each direction, he was passing by an apartment complex and kind of a driveway leading in and out of the apartment complex. You'll hear Mr. Escobar testify that as he's passing this driveway, that's when the defendant's vehicle pulled out and hit the front passenger side of his vehicle. You'll hear Mr. Escobar testify about the force that impact caused on his body and how it caused his body to move inside his vehicle. Notably, it pushed him to the left and caused his elbow to hit the side door. You hear Mr. Escobar testify about what he did immediately after the accident, called the police and tried to assess the situation and everything. And you hear Mr. Escobar testify that after the incident, he had to drive his vehicle to his father's house because he was worried it wouldn't make it all the way home. Mr. Escobar then started experiencing immediate pain in his left elbow that hit the door, and then later developed pain in his neck and his back. You'll hear Mr. Escobar testify that after waiting to see if the pain would go away on its own, after about a week, he started chiropractic treatment. You'll hear Mr. Escobar testify about the treatment, the specific treatments that were given to him by Celebrity Healthcare Chiropractic, and the effects that it had and how it was successful in alleviating his pain. You also hear Mr. Escobar testify about the other doctors who treated him at Celebrity Healthcare and the care and medication that they prescribed to him. Mr. Escobar treated for a little over a month, and at the end of it, fortunately, his pain symptoms had subsided. Now, you'll also hear the defendant's version of everything, and it's kind of a completely different story that you're going to hear. I ask that you just hold off on making any judgments until you've heard both sides of the story. And then, again, remember that burden of proof that we're applying to everything. By a preponderance of the evidence, or more likely than not. Then I want you to ask yourselves, after you've heard both versions of the story, which one seems more credible to you, more likely than not? And I feel that after you've heard all the evidence and heard all the testimony from both witnesses, that we will have proven our case by a preponderance of the evidence, by that more likely than not standard, that the accident and all of the injuries caused to Mr. Escobar were caused by one thing and one thing only, and that's the negligence of the defendant. Thank you, ladies and gentlemen. You're mute, Jeff.
Mr. Archibald, you have 10 minutes.
Thank you, Your Honor. May it please the court, counsel, ladies and gentlemen of the jury, you have a very important role in deciding how this case finally comes out. We've been waiting since June 3rd, 2017 to come to a conclusion. We haven't been able to decide, so now we present it to you. As plaintiff's counsel has pointed out, this accident happened on Peterson Road around 10 p.m. He mentioned a couple more facts about what plaintiffs anticipate the evidence will show, but I wanted to talk about what the evidence the defendants anticipate it will show. First, we got to focus on 3 things, the 3 C's of this accident: conduct, causation, and credibility. What conduct of my client is negligent? The evidence will show that my client did nothing but act ordinarily careful. There won't be any evidence of any using a cell phone. There won't be any evidence of any tampering with a radio or eating or drinking in the car. The evidence won't have any support for a negligence answer. Causation. The evidence will have to support a finding that this accident was caused by negligence on my client's behalf. That negligence could not, or the evidence will not show that action, the conduct on my client, was anything but ordinarily careful. So therefore, the evidence isn't going to have anything to support that. not only do we have to look at the accident itself, but causation of the injuries and the consistency between the testimony between the plaintiff and the medical records and the bills that are related to each. The evidence will show that there's going to be several inconsistencies between the testimony that plaintiff will likely elicit and the records themselves. So pay attention to the records, the inconsistent statements, and the fact that there is no evidence of a police report. You're not going to hear anything about an ambulance. You're not going to hear anything about an ER visit. And there's not going to be any evidence to show that there were any injuries caused by this accident. Conduct, causation, and credibility. The credibility of the evidence. Not only the documents that we'll produce, not only the testimony, but the people and the words that they say in comparison to one another and supported by or lack thereof of the records. Conduct, causation, and credibility. The evidence won't show that my client did anything but act with ordinary care. The causation can't, you won't see any evidence that there's a direct link between the causation or any negligence or any conduct and these injuries. And the credibility is rife with inconsistencies, and as I anticipate the evidence will show. And at the end of the day, I'm going to ask that you return a verdict in favor of my client. Thank you.
Okay, guys, so we're going to go ahead and send you back to the jury room. You're welcome to stay on Zoom. We're going to reconvene at 1 o'clock. And we'll start with the opening statements. I'm sorry, not with the plaintiff's case. I feel pretty comfortable we'll be able to finish these relatively quickly, hopefully by sometime mid-afternoon. And then let me ask one question. I guess the one thing that may come up this afternoon is the marshal's office may be trying to contact you about delivering the device, and that may be during the trial. So if you do get a phone call from the marshal's office, or if you get somebody knocking on your door, please just let us know. We'll take a quick break so you can go get your device. Does that make sense?
Mm-hmm.
Does anyone have any questions?
I have a question.
Yeah.
Is there a specific number we can look ahead to? I get work calls on my personal cell phone, so it's hard to determine whether there'll be.
I'm so sorry. I
Marshall.
don't know the marshal's number. We'll try to find that out during the lunch hour, and if we can, I'll let you know.
Sure. Okay.
But it's a different department than I'm in, so I don't know who exactly is doing that. So, but if I can, I'll definitely let you know. And thank you for bringing that up. Any other questions? Any question? And let me just say one last thing. I say this whenever juries are in person, and it's even more important now. I once had a case, I've told this story probably over 100 times, where we were at the courthouse, and one of the jurors, I tell them, where they can go to lunch. There's all these restaurants, or they go to the basement for cafeteria. And we once had a juror go to Neiman Marcus for lunch, and she was 45 minutes late. Well, guess what happened during those 45 minutes? We all had to wait. Exactly,
Yeah.
Ms. Irving. We all had to wait. And so when we come back at 1, if one of you is 30 minutes late or 20 minutes late, that means everyone's going to have to wait. So please make sure you're back on at 1. And does anyone else have any questions? All right, guys, thank you so much for your service, and we'll see you back at 1 o'clock, okay? I'm going to go ahead and put you in the jury room.
Thank you.
Thank you, guys. Oops, I don't think I can. I think you guys can they join it on their own? Okay, sorry. I'm still learning this stuff. Okay, I'm gonna move you to the jury room. Oh, wait, has anyone left? You should be getting invitations, guys. Go to jury to go room 2. All right, has everyone gotten invitations?
No.
No, I haven't.
No.
No.
No,
No one has gotten invitations?
no.
No.
Mm-mm.
Let me do this. Let me recreate.